Policymakers at the federal and state level in the United States, as well as globally. We're excited to host a series of conversations today featuring paper authors and important stakeholders in the privacy, data protection, and AI governance fields. My name is Justine Gluck. I am an AI policy analyst here at the Future of Privacy Forum and the MC for today's event. Again, excited to welcome all of you to our webinar. This is part one of two. We will have an additional webinar at this time next week. So just flagging that for folks who are interested. Um, and excited here to have folks joining us today from across academia, industry, civil society, government. So thank you all for tuning in and for being a part of this event. Before we start and to kick off our event, I do just want to offer a few words of thanks and some housekeeping notes. So first, we do want to thank the scholars, advocates, and advisory board members who are engaged with us to explore the future of privacy and AI here at FPF. Second, a really special thank you to the people who worked over many months to make this event happen, particularly across our events and communications teams. So thank you, Nicole, Divinity, Megan, Adrian, Celeste, and others at FPF. Thank you so much for your hard work throughout this process. Also, thank you to the entire FPF US and global policy teams for being excellent judges in this process. As well as a thank you to some of our external judges. So Anne, Deb, Michael, Coben, Jocelyn, Stacy. Thank you all for being a part of this judging process. And just an extra thanks to Jordan, Daniel, Matthew, and Doug here at FPF for helping to lead the final round of judging. Today's event certainly wouldn't be possible without all of you. So thanks so much. And a quick housekeeping note. So for today's program, we're going to have each paper's authors, as well as a discussant, review their winning paper for about 10 minutes, and then open up to respond to audience questions for about 5 minutes. So if you in the audience do have a question you would like to ask the paper's authors, we're going to ask that you please drop your questions in the Q&A feature of Zoom. So not the chat, but specifically the Q&A feature. We will have some limited time for questions, but we do hope to raise some from folks in the audience to the discussant. So again, please drop your questions specifically in the Q&A feature of Zoom. That's where we will be pulling some questions from. And I do want to flag for all those on the call that this webinar is being recorded and will be available for viewing later. So without further ado, I want to move into the discussion segment of today's event. During this segment, again, the authors of the winning papers will be joined by an expert discussant, 10-minute discussion, followed by that 5-minute Q&A. So I do want to encourage everyone on the call to take a look at our PPPM digest, which includes summaries of each of the winning papers, as well as links to read the full paper. So we'll drop that link to the digest in the chat here shortly. And with that being said, I also do want to take a moment to acknowledge a few of the papers that won't be presented today. First, I want to acknowledge our honorable mentions this year. So this year we recognize 2 honorable mentions for the General PPPM Award. This year's awardees were Brokering Safety by Chinmay Sharma, Thomas Kadri, and Sam Adler. Our second honorable mention went to Focusing Privacy Law by Paul Ohm. So thank you to all those authors for both amazing papers. Second, as part of PPPM, we recognize Leading Student Scholarship as well. So this year we did select one student paper for recognition for a student award. That award went to a paper entitled Decoding Consent Managers under the Digital Personal Data Protection Act by Aditya Shushant. So again, awesome paper. These papers were all exceptional, and we want to thank all of you for your work and your leadership in this space. So without further delay, please welcome our first author, Arvind Narayanan, who is presenting his paper, AI as a Normal Technology, and he'll be joined by Ed Britan from Salesforce. So I'll turn it over to them.
Hey, thank you so much. So happy to be here with Professor Narayanan and discussing this paper, which I think privacy professionals are going to find really relatable. He wrote it with Sayesh Kapoor, AI as Normal Technology. And what I really like about it is instead of the usual utopian promises or existential fears that we're hearing, they argue we should view AI like other transformative technologies. It's powerful, it's controllable, it's evolving gradually. 3 points that really resonate with me as a privacy professional. First, the paper frames the need for control in ways that us privacy professionals immediately recognize: auditing, monitoring, access controls, compliance frameworks, human oversight of AI. was all music to my ears, Professor, and I really love that view. Second, targeted regulation builds trust and drives adoption by providing certainty. And I fully believe the lack of clear global standards is paralyzing many organizations right now. So really love that point. And democratizing AI requires solving the trust problem first. We've seen this playbook work well before with cloud adoption. Organizations were terrified to move to the cloud as recently as 2014. But building trust through governance paid off when COVID hit just 6 years later, because the cloud was necessary for keeping the economy going through that period. So I think AI adoption is going to prove just as critical. Arvind's paper charts a responsible risk-based approach to measured AI adoption, grounded in the sorts of controls that us privacy professionals champion. So Arvind, welcome. Thank you for the paper. I love this discussion. You wanted to go right into questions and frame the discussion around that. So I'll start with something that is really personal for me as a lawyer. There's a stark contrast between your paper's thesis and some recent industry commentary from Microsoft's AI chief, Mustafa Suleyman, who recently suggested that AI and agents will replace human professionals within 12 to 18 months. Your paper argues the opposite, that AI's impact will unfold over decades, not months, and that many professional tasks requiring creativity and judgment, which I would like to think my role requires, are inherently hard to measure and therefore hard to automate. Can you address this disconnect? And what do you think leaders like Suleyman are missing when they predict such rapid displacement?
Thank you, and happy to address those. Hi, everybody. Here, a little bit of an echo, unfortunately, but hopefully it's okay on your end. My name is Arvind Narayanan. I'm a computer scientist. Just wanted to mention that before I talk about Ed's question, because a lot of our research is very pertinent to this. So I think the core mental model that many technologists have when making these predictions about rapid labor displacement is they're looking at these capability benchmarks. And yeah, I lead a whole team looking at these benchmarks, what they're good for, what they're not good for. I think what many tech leaders are saying is AI is going up rapidly on these capability benchmarks. And when that capability threshold reaches human performance, of course, it's going to make sense to replace people with much cheaper AI. And as AI takes over more and more tasks, eventually it's going to start replacing jobs. So I think they are unfortunately wrong, or fortunately wrong, actually, both on the technical front and in terms of the organizational and sociological understanding of jobs. On the technical front, what our research shows is that capability is just one dimension. It's a dimension that the industry pays a lot of attention to, but if you want to reliably perform a job, you have to look at a lot of other things. How good is the consistency? How good is AI performance when conditions shift slightly? So that's something we've been looking at for years. And actually, finally, just last week, we put out a paper saying towards the science of AI agent reliability, if folks are interested. And it shows there's a very clear gap between capability and reliability. So just purely on the technical front, I don't think AI is either, close to human performance or rapidly improving. What we have found is that reliability has only improved modestly over the last 2 years or so. So that's one big thing I feel that a lot of tech leaders are missing. And the second is this idea that as AI starts to replace tasks, it's going to take over jobs. I don't think that is really supported by history or by a good understanding of the economics, labor economics and so forth. What we've seen historically is that as automation increases, certain tasks get done by machines, the nature of the job shifts. People start doing a different set of tasks. They move higher up the abstraction chain, if you will, tasks requiring more creativity and judgment. And what it means to be a lawyer or a professor or anything else changes as more technical tools come into the picture. And in these first few years of generative AI adoption, that's very much what we're seeing. So, for instance, when we look at software engineering, what many software engineers are doing is no longer directly typing the code, but higher level tasks involving controlling these AI agents. And when you look at the number of job postings for software engineers, that number has actually been going up, not down, even though so much of coding can now be done by these AI agents. So yeah, I'll stop there.
Well, I would love to hear you keep going, because all of this is like a breath of fresh air for me, as I'm sure many of us are doom scrolling constantly and seeing all these things that make us really anxious. And I wish I could be your student, because you really are calming me down. But next question would be around how you reframed control in the paper. I thought you made a really compelling case that control doesn't just mean alignment or keeping humans in the loop. It includes auditing, monitoring, access controls, compliance frameworks. These are all things that my team and I work on every day. And I really appreciate this view, Because I think for all privacy professionals, we already live in this world of compliance frameworks and governance for data protection, and we can really help organizations to apply these concepts to AI. So I'm interested, can you explain why this broader conception of control is so important for AI and what it means practically for how enterprises should be deploying AI responsibly?
Yeah, definitely. Let's look at a practical example of alignment failure. There was that famous case of the Air Canada chatbot. This, by the way, connects back to your previous question. A couple of years ago, everybody thought, oh, chatbots, customer service representatives, that's going to be the first thing to get automated, and it's right there in the name, chatbot. But when people started deploying this, they found that these bots are unreliable. And in the Air Canada case, there was a famous case where it made up a refund policy that actually did not exist, and the customer suit went all the way to the Canadian Supreme Court, and the court actually forced the airline to abide by this non-existent refund policy. So as companies start to discover that there are liability risks in this kind of uncontrolled sort of adoption, control starts to become much more important. And it's not a purely technical conception of control. It's not merely aligning the chatbot so that let's get the hallucination rate to zero. That's never going to happen. So you have to figure out what are going to be the organizational layers, considering that the error rate is never going to go to zero. And in the Air Canada case and in similar cases, people are saying maybe the answer needs to be insurance. So when a chatbot goes wrong and you suffer some financial harm, what is the way to make that customer right? Um, Make that customer whole. So that to me fits under this broader conception of control, right? In addition to all of the points that you brought up, that we, monitoring, access controls, compliance frameworks, auditing, etc. So it's a very broad milieu as far as I'm concerned. It cannot be left to purely a technical understanding of control because those technical aspects are going to fail. And then you have to think about what happens. How do you deal with that failure?
Absolutely, and really love that view. And I also loved your view on regulation because I'm, a true believer that regulation can help build trust and certainty. And you advocate for sector-specific regulation rather than broad, comprehensive AI laws. What does good AI regulation look like, and where do you see the biggest gaps or mistakes being made in current policy discussions?
Yeah, definitely. To me, I think almost any interesting AI regulation discussion has to happen in a sector specific way because a lot of the issues that come up are so different from sector to sector. If you look at self-driving cars, for instance, you have to think about what are the safety implications. There's a potential for saving so many lives by cutting down the accident rate. But then when accidents do happen, what is the accountability? You have to think about what are the implications for job loss, et cetera. Right, and that is unlike many other. So if you look at AI and science, for instance, some of the policy debates there are very different. Some people are saying we have to invest a lot more in AI for accelerating science, whereas I and some others have said, hey, wait a minute, that's already happening. Maybe what we need to spend our federal dollars on is actually on the kinds of science that are resistant to AI acceleration, because if we don't fund those are just going to get dropped, and we're going to have big gaps in the scientific literature because it doesn't fall into this AI hype cycle. So again, very different kinds of issues. And instead of that, if we talk about AI regulation with a broad brush, very often it just leads to these platitudes around how do we maximize the benefits and minimize the risks. I think to actually answer those questions, we do have to get sector specific.
That's excellent. I'd love to be in the room when you're having these sorts of conversations with policymakers. And yeah, next time you come to DC, let me know. I really love these views and would love to carry them myself. You also talked a lot about diffusion versus concentration and explicitly rejected the idea of AI non-proliferation as an approach and argue instead for diffusion, getting AI into the hands of more people, supporting open models. This runs a lot of counter to a lot of current policy discourse. And I'm interested, why do you believe diffusion is actually safer than concentration, particularly given privacy and security concerns around it?
Yeah, it's simply that concentration is very fragile. So concentration is the idea that beyond a certain capability threshold, we can have models, for example, that are openly available for anyone to download, use, improve upon, etc. And I see the appeal of that approach. The problem is that when you look at how quickly, literally exponentially, the costs of building these AI models are dropping, right? Something that used to require uh, the resources of a frontier AI lab can now be done by an academic research group. And eventually it's going to be something that someone can do in their basement. And so I think the approach of ensuring that only a few frontier AI labs are able to build AI and that's your choke point for regulation, that's going to be extremely fragile. Eventually, that dam is going to break. And when that dam breaks, you're going to end up with no defenses outside the AI model. So, for instance, if we're concerned about misinformation, we need to have misinformation interventions on social media. If we're concerned about the use of AI models for cyber risk, we have to be incentivizing the use of those same AI models by defenders so that companies can find and fix security vulnerabilities before they put their software out there. So, fortunately, those kinds of things are happening now. And they're happening now because we have learned to live we're gradually learning to live in a world where we acknowledge that these models are going to be widely available and you can't put them back in the box. And I think trying to put them back in the box would be a mistake.
Excellent. And another topic that is important to me, I have a lot of conversations with customers, and many organizations, particularly risk-averse ones, are paralyzed right now by uncertainty, unclear regulation, unclear standards, unclear what the best practices are. It's not, they want to do the right thing, and they're very risk-averse. So, based on your framework, what practical advice would you give? And this is very self-serving to an enterprise leader trying to navigate AI adoption responsibly today.
I think a lot of organizations have to learn to generate evidence internally. So one way in which I've pointed out lots of similarities between AI and past technologies, but I think one difference is also worth pointing out. So if we think about some past technology, such as, let's say, Zoom or video conferencing, when enterprises were deciding whether to adopt that, they could look at the experience of their colleagues at other companies and see how it worked out for them, right? And it's very tempting to apply that same approach to AI and bring in a consulting firm and just based on their knowledge of how it worked out for other peers in your industry, try to make some educated guesses about how AI adoption might work for you and what use cases to focus on. But in my experience, the the benefits, pitfalls, etc., really tend to be hyper specific to not just which sector or industry you're in, but the specific, you know, workflows that you have within your organization, the specific data distribution that you have from your customers, so that a tool that works really well for one company or one team might not work that well for another company or another team. So I think there has to be a culture of piloting and experimentation. What we saw with the first couple of years of generative AI was, of course, a lot of piloting and experimentation, and that's good. And now companies are saying, okay, we're shifting from an experimentation approach to we're solidifying our AI strategy. I understand that need for more certainty, but I think while companies select a few use cases to scale up and deploy more broadly, I think they should continue experimenting and learning from new use cases because the capability frontier is quickly shifting, and there's no way other than internal pilots to know what is or is not going to work for your specific organization.
Excellent. And I think we're at time on our Q&A, and it looks like we have a question from the audience. So I'm trying to, is that in the chat? Oh,
How can regulations meet the level of granularity needed to be sector specific in such a fast changing field? Yeah, that's a great question. And one general principle perhaps is to focus less on regulating the technology and more on regulating what human actors are going to do with the technology. So if regulation is tailored to what are the harms that can arise, I think that set of harms tends to be much more stable over time compared to the specific affordances or capability levels of whatever is the latest model that's out there. So applying that principle, for instance, to let's say deep fakes and non-consensual nudes, which has been a huge issue. One way to think about it is what defenses should we put into the latest models? Well, a new model that might come out where that defense doesn't work that well anymore. But if you focus on, perhaps criminalizing some of this non-consensual activity or figuring out what are the intermediaries, what are the middlemen, what are the app stores that are distributing these apps widely that enable people to perform this on a massive scale and putting pressure on those intermediaries to change their policies, that is much more robust and is not that sensitive to the latest capabilities of the models.
excellent. Are we at time or?
I think we're at time. Appreciate both of you for have this great discussion.
Thank you.
Next up, we're gonna welcome our second author. So Alicia Solow-Niederman is going to be presenting her paper AI and Doctrinal Collapse, and she'll be joined by Christa from Cleveland State University. So I'm going to give you all the floor.
Okay, wonderful. Well, thanks so much for having us. I really enjoyed this paper. Alicia, I think it's really fascinating. So one of the things that Alicia's paper does, and I'm just going to kind of briefly mention a high level view and then jump into questions to help Alicia better explain her paper. But basically, this compares copyright law and privacy law to try to show that there is what she calls a doctrinal collapse happening that could have negative impacts for society. And so I wanted to jump straight in and ask Alicia, with this inter-regime doctrinal collapse, what is that and why is AI making it more visible right now?
Sure, and thank you so much for the opportunity. I will note I take almost 2 parts of my law review article to describe this concept and unpack it, but I will try to do brief justice to it now. So, at a high level, inter-regime doctrinal collapse occurs when there are two partially overlapping legal regimes that both apply to the same regulated object, like data. But the boundaries between the regimes blur, and one regime collapses into the other. So, inter-regime, because it involves substantively unrelated legal fields rather than one field of law. So, collapse within tort law or within, say, constitutional law. Now, before I say more, because I do want to elaborate a bit more on this, I need to stress something else about the argument, which is that when I say collapse, I imagine you might have kind of a negative reaction to that, which makes perfect sense. You don't want to be like driving on a bridge and have it collapse. That's a bad thing. But in the sense I use it in the article, inter-regime doctrinal collapse is purely descriptive. Whether it is good or bad depends on what it enables. So the question becomes which actors are empowered to exploit a state of collapse, and what are the political economy and rule of law consequences? So, to make that concrete, and this brings me to why it's salient now, I focus in the article on two regimes that regulate data, especially forcefully, as Christa notes, copyright law and information privacy law. There is overlap between those two legal regimes, and that kind of partial overlap is a necessary condition for the kind of collapse I'm discussing in my piece. But it's not enough. To get inter-regime doctrinal collapse, we need to have overlapping domains, blurring of those two domains, and then there have to be irreconcilable doctrinal and normative lines underneath each one. I know that's kind of theoretical, and this is a policy-oriented piece, so I want to unpack that a little more. By blurring, I focus on conceptual blurring, where the categories within law lose their meaning, and functional blurring, where the two fields of law aren't reliably guiding or constraining conduct. Pardon me. And when I say irreconcilable, I mean that copyright and information privacy are different bodies of law. They have different legal rules and they have different normative rationales. So, stylized fashion copyright law focuses on authorial incentives to produce creative works while also recognizing the importance of the public domain. And that's a very property driven logic. Privacy law, at least on the books, is about control, offering individuals control over their own personal data and foregrounding individual autonomy. So, when we focus on a particular model of collapse, where one domain, privacy law, has longstanding weaknesses, then that creates conditions for copyright law and privacy law to kind of be toggled between in ways that allow sophisticated private actors to exploit those weaknesses to their advantages. And then that further blurs the two regimes and compounds the collapse. And the reason this is so important right now is quite simple. AI runs on data. We need a lot of data to create and refine AI systems. And again, because both copyright law and privacy law regulate data, both regimes come into play in data acquisition.
That's great. And one of the examples that you mentioned in the paper is OpenAI, for example, making competing claims that they should have access to and be able to use data that they have scraped or acquired from other locations, both under privacy rules and under copyright fair use principles, and yet also claiming some protection over the data that they are generating internally or the outputs of their data in some situations as well. And so I'm curious when, we've had for centuries, companies have taken advantage of the crossover between different legal regimes. And in this space of copyright versus the proprietary data and things like that, we've also had this common issue where companies will claim that something might not be copyrightable, but should still be treated as proprietary, for example, if it's kept as a trade secret. So why is it problematic that companies are sort of just maximizing shareholder value here, essentially? Why is that problematic versus, or I guess maybe tell me about the problems behind that and why this is an
Sure.
issue versus just normal business as usual?
Sure. Well, I mean, first of all, I do think in some sense it is business as usual. And I also think that can itself be a problem. One of the themes in my research is that law often puts pressure on and exposes what were longstanding latent underlying weaknesses. And maybe we decide that just business as usual and we're fine with any costs, but maybe it's also an opportunity to interrogate the underlying values and think about who is hurt, who is harmed by the current state of affairs. So that's thing one. Thing two is I think I just want to back up. So I do mention OpenAI in the paper. I want to note that when I mention a particular company here or in my other scholarship, it is purely illustrative. I am not trying to call out any one actor, but I think it's a helpful example to dig into. We could just suppose that a generic company scrapes data from the internet to train an AI model. And initially they say that it's publicly available data. So it's not subject to privacy restrictions because individuals voluntarily disclosed it. And then, as you note, that also means it's not liable for copyright infringement, either because it's publicly available in the first instance. Note that's not actually a legal term of art, publicly available, but it appears all over the place in both generative AI litigation and in public-facing rhetoric. And then at the same time, that same company refuses to disclose its training data, saying those data are proprietary and confidential. And then suddenly, if there's a discovery battle during litigation, they argue that the user privacy requires non-disclosure of the data, even though individual privacy was denied once data had been voluntarily shared with a third party. So if you're feeling confused, that's exactly the point. It becomes really, really tough to predict and trace which doctrine applies when we have the same regulatory object data being controlled and toggled in these same ways. And so that's my argument about why this is problematic. Law, of course, often overlaps. It often has ambiguities. I don't see that as itself a problem, and we wouldn't want an overly formalistic body of law. It's inter-regime doctrinal collapse is the structural condition when we have the latent tensions between these regimes. So I think the trade secret example you raise is actually a useful contract because it shows us what non-problematic collapse can look like. In that scenario, we have different doctrines that apply to different parties at different moments in ways that are at least predictable and legible ahead of time. What I'm trying to describe here is different. We have the same party invoking incompatible legal positions about the same data strategically, depending on what's advantageous at a given moment. So it's that exploitation of the legal regimes that troubles me. I can speak more about the patterns of domain exploitation that I identify in the paper, but I don't know if you have other questions or other places you want to go.
Yeah, it's related. I mean, you mentioned an example of the use in litigation and in discovery disputes. So why is it maybe you can explain that example as one area where there's that potential conflict between the privacy and copyright space?
Sure. I mean, I think those are an especially clear discovery disputes. That's what I mean by those are a really good example of the toggling between regimes, with privacy being disregarded and then selectively invoked to suit the interests of a player at a particular moment in time. So, as I briefly mentioned, remember at the data acquisition stage, a party might say that the data is publicly available, we scraped it, there's no copyright claim, and there's no privacy claim in it. And then later, if the company is sued for alleged copyright infringement, one of the dozens and dozens pending lawsuits, it might double down on those same arguments about the public nature of data. They might also highlight a user's choice to accept a platform's terms of services and the privacy policy, which would rebut or seek to rebut any privacy objections, saying, your data was voluntarily provided, it was voluntarily licensed to the company. But then in discovery, the company may refuse to disclose the training data and say, well, this is proprietary, or might even invoke other arguments about privacy as a shield. So information privacy arguments don't feature prominently in the initial public statements. They don't feature prominently in the initial legal briefs. But then as soon as the plaintiffs seek access to the data, the company may, in the process of their copyright defense, suddenly argue that sharing it would violate user privacy interests. So I find it curious that privacy didn't matter before when the company was training the model, it didn't matter during the deployment of the system, it didn't matter in the earlier court filings or even in public statements. But then when it can be strategically invoked to resist discovery, it suddenly becomes this leading argument and even a public facing PR opportunity. So I think there may well actually be valid privacy interests here. I don't mean to suggest there aren't, but my point is actually more basic, which is that when private actors can choose which doctrines apply at which points, depending on what serves them, controlling legal regimes lose their consistency, they lose their coherence. And I see that as a rule of law problem.
Yeah, great. Thank you. And I see that we have an audience question as well. And that actually ties in a little bit with one of the other questions I was going to ask. So just as some background here, and you'll see why this relates to the question in a second. But you've mentioned in the paper two different strategies the companies are using to acquire data, buying data and asking customers for data, or essentially using terms of service. Yeah, a sort of a sufficient ask under current US policy approaches, so or under current US laws. And you also mentioned briefly that in the EU, AI companies have a different approach to making that ask than they do in the US. And so I was kind of curious, it was just a brief mention. I was curious, does that change the outcome? And is the EU privacy model one potential solution? And that ties in a bit with the audience question here, which is if doctrinal collapse is inherently bad, what does a policy approach look like to addressing this failure?
Yeah. So I think that what the GDPR example suggests is that we've made intentional choices in the structure of privacy law, or I shouldn't say intentional choice. There are choices in the structure of privacy law that do make it asymmetrically weak in the US as opposed to the structure of copyright law. And that's the model of collapse I'm focused on in this paper, that asymmetry and what sorts of exploitation it facilitates. And so the buy and the ask, and I think it's helpful to actually back up a step because it does relate to my policy responses. I think those also have strong political economy ramifications. The ask is going to be most easily executed and taken advantage of by well-resourced actors who already have platform relationships with particular kinds of users, or who have systems of products where they, like a social media company that can ask for data from a large set of users. A buy is going to be most executed by haves, meaning actors with resources and influence to execute licensing agreements. And so I would focus on particular exploitative tactics or outcomes that we find problematic or not. To me, and this is, I think it speaks to the question in the Q&A, I think it's a bad outcome when exploitation disproportionately advantaged well-resourced players at the expense of ordinary content creators and ordinary people. And also, I think it's a problem if exploitation muddles the legibility and coherence of law itself. If you can't predict which regime will govern and control at a particular moment in time ahead of time, I don't think that serves our system of law. That's why I call it a rule of law problem. And so I don't think that collapse is something that can be solved because I don't see collapse as itself a problem. It's about the exploitation it enables. And so I think one policy outcome is simply to recognize collapse. I know that sounds mushy, but I think that recognition can both surface the underlying tussles, the normative points of conflict between regimes, and then also potentially bring together new policy coalitions, like users with privacy interests and copyright interests. And then I think there are also a set of other institutional responses. I think there are ways we could draw on conflict of laws and empower the courts as potential institutional managers of collapse in the context of particular legal disputes, not allowing companies to mount mutually incompatible claims. And then I also think a deeper, far-reaching, and one of the most concrete reform points I hope legislators and policymakers take away is that when we have weak information privacy laws, it doesn't just threaten privacy. It also affects other fields of law and the entire structure of law. And so I would think about how to adopt stronger privacy laws that make that copyright privacy relationship less asymmetrical and then avoid undermining the structure of law and the protections across both fields and so on.
I think that ties in well with our last audience question. I know we have less than a minute left, but it sounds like the some of the policy approaches that you are pushing forward, the key one being let's enhance privacy law. And so it sounds like perhaps maybe a federal privacy law would be useful for that, something comprehensive and stronger. Is that something you agree with? And then another question I had tied on to that, which is what else can we use to address this? And is there a place for something like the FTC or a state AG office to step in and say that a large company using user data in ways that the users don't understand could potentially be unfair competition? And if it's not, should we change that and make that unfair competition?
I hesitate to rush through such a nuanced question in 30 seconds or less, but I do think the major takeaway is we need to strengthen privacy law and we need the resources for enforcers on the ground at the state and federal level to both think about how to leverage existing laws and then consider whether there are gaps in particular places.
That's great. Thanks.
Thanks to
Thank
both of you. Gave us a lot to think about, a lot more questions posed there. But for our interest of time, we're going to move on to our third set of authors. So I want to introduce Prem Trivedi and Matt Steinberg presenting their paper, AI Agents and Memory, Privacy and Power in the Model Context Protocol Era. And they're going to be joined by Gabriel Nicholas from Anthropic. So I'll turn it over to you all.
Great. Thank you so much. And I am very excited to be discussing this paper with Matt Steinberg, a former fellow at New America Open Technology Institute, now a fellow at the Knight Georgetown Institute, as well as Prem Trivedi, the director of the Open Technology Institute. There are so many questions that we are wrestling with in the AI policy world. How should we govern increasingly capable models? What does this mean for the future of regulation? How do we deal with big issues like safety and bias and accountability? There's been a lot of ink spilled on these issues, but one of my favorite things about this paper is that it does not spill anymore. Instead, this paper looks where very few other scholars are looking at the plumbing that connects these models to the world, specifically at an open source standard called Model Context Protocol, which Anthropic built in late 2024, has been used by all of the major frontier labs, and has been donated to be governed by the Linux Foundation in late 2025. MCP is essentially a USB-C port for AI systems that let them plug into external services, moving data and letting tool developers describe to the model what a tool is and how to use it. When you connect your email, your calendar, your health records, a hardware robot, any of these things to a language model, MCP is the pipes. It is what allows these systems to communicate with the outside world and actually take actions. It is an open source standard, and to use the buzzword du jour, it is what makes these models agentic. In this paper, Matt and Prem argue that AI has shifted from tools that generate information and synthesize information to tools that are actually able to interact with the world. And MCP is the hinge point where those interactions happen and is therefore the place where governance should be focused. It's where data crosses into the model's context. It is where third parties are able to have input into what the model does. And it's a very important part for how we think about maintaining a competitive ecosystem, as well as what AI systems remember about us around personalization and data flows. The thing that I like the most about this paper is that I think it really serves as a theoretical bridge between two worlds that have not been traditionally talking to each other. AI agent discourse is largely dominated by, if we are being totally honest with ourselves, LinkedIn growth hackers. I think this is really detrimental, and it is generally leading agentic AI to be largely disregarded as hype by the larger academic community and really not warranting serious academic attention. And I think this paper is a land bridge, and I hope that many information scholars will cross it. It shows that the concepts that the community has spent decades developing, contextual integrity, expected data flows, data minimization, interoperability, the perennial failure of notice and consent, all of these actually have purchase in the world of agentic AI. And I think it opens the door for this community to seriously engage with what is coming. So enough about this paper, I want to talk to the authors about, ask them a couple of questions, and then give space to you all to have any follow-ups. Let me start with you, Matt. In this paper, you talk about that context is the new moat. Could you unpack what you mean by that?
Yeah, context being the new moat is a phrase that has been very important in our paper when talking about how data and MCP affect the economic incentives around AI. Firstly, just to kind of quickly define what we mean by context, it's the data an LLM uses to interpret a prompt and then generate its response. That's your preferences, your documents, your behavioral history, everything it can be used to understand who you are. And so leading AI companies use this context to create a moat, sort of meaning it's how they keep a competitive advantage. Because at this point, these models are all getting insanely smart. Many people believe that the quality across AI models is converging. So a really important differentiator is how personalized each one can make its answers to you and how well a model can know your specific context. This kind of creates what we were calling in the paper a flywheel effect. You use a model, it collects data on you, so it gives you better answers, then you want to use it more, so it learns even more about you, and then that cycle just keeps accelerating, and that data sort of creates a lock-in effect. But what we found with MCP is that it can really be an equalizer. If data and context are what create a competitive model, then being able to easily connect to external tools helps new models quickly gain context and compete. So MCP could evolve in kind of one of two ways. It could be functionally controlled by a few incumbents and keep that flywheel going, or it can stay in open source, which would be really important and kind of help serve as a tool that promotes competitive markets.
Great. Matt, you opened up the idea of memory and personalization. Prem, I want to ask, how does AI memory actually work today, and how does that differ from how you'd like to see it work?
Thanks, Gabe, very much, and thanks to FPF as well. So as Matt and I explained in the paper, memory allows agents to retain context across sessions, tools, and platforms. And I think a recent, very useful framework for understanding AI memory comes from a recent paper from Miranda Bogan and Ruchika Joshi at CDT. They talk about 3 dimensions of memory, which we find helpful. So what memory is about, and that can range from benign preferences to much more sensitive financial or health data. How it's stored, so that could be in model weights in some cases or in external structures, and how long it persists, right? So that's retention limits for the privacy folks who are thinking about that. And as we note in the paper, in many systems, memories aren't fragmented by session by default, and data varying widely in sensitivity isn't necessarily segregated. Some models may do this to varying extents, others don't. And so a model that's aware of your health condition, for example, connected to a health insurance agent, now creates real leakage and unfairness risks. And so the choices that are being made right now are really likely to vary across companies and are consequential for privacy, for user autonomy, for transparency, right? And I think one of the things we try to convey, and is worth emphasizing here, privacy risks in single user chatbot interactions are already quite significant. They compound quite a bit as agents interact with one another, as purpose limitation gets harder to enforce, and as potentially sensitive contexts start to bleed across an ecosystem of tasks. And all of that is concerning, given incentives that are going to favor monetization through personalization and ads. So what would we like to see instead? Very briefly, and acknowledging this is an ideal that has got to meet the road of commercial feasibility, right? So I think memory should be classifiable by type, have some tags and safeguards that can travel with data when exchanged across agents. And purpose use limitations and retention periods should combine strong defaults for sensitive data categories. And we could have totally separate conversation about what those should be with user controllable and conversationally accessible settings. To your point, Gabe, about what's the nature of the interaction with an agent like. So ideally, simple enough that a request in a chat exchange like, don't store anything about my mental health or my emotional states after this conversation can actually be honored via settings.
So Prem, you mentioned ads. We know that since this paper was published, that some frontier models labs are building ads or thinking about building ads into their products. What does your paper tell us about how we should be thinking about this moment? And if you could go back and add a section on advertising, what would it say?
I could start here. Yeah, Yeah, this is something we actually had talked about when we were writing the paper, but it has arrived faster than we expected. So advertising is going to be a real stress test for the privacy concerns that Prem just mentioned. Advertising and chatbots, it brings up a lot of questions around inference and design, and that's kind of a whole conversation unto itself. But in terms of our paper and the way agents will change advertising, they're really going to change the scope of what we're looking at in terms of data. If an agent is accessing your email, your shopping history, your banking apps, and then inferring your mood, stress, intent, that means the behavioral surface area used for targeted ads is going to be dramatically expanded. So agents and MCP for that matter mean that advertising isn't just based on what you type into a box. Ads could be based on persistent and inferred cross-service memory. And then when it comes to data privacy, that's not really something we've seen before.
So picking up on that, right? So, and as you said at the outset, Gabe, MCP is a coordination layer. It doesn't encode restrictions on what data subsequently gets used for. And so in the absence of guardrails, memory can get repurposed in ways that users never anticipated, including for ads. And so you end up in a world where you might have a gap between what AI companies are promising when you interact directly with them, including whether they run ads, whether they have no ads commitments, and then what happens then when that data flows through a third-party MCP server, right? I think many MCP servers likely can't define the nature of being data that's being accessed, the consent requirements. They're probably not logging or evaluating legal bases for accessing them. And so this might create potential compliance problems under existing privacy laws. To put a little bit of a finer point on it, nothing in the MCP protocol stops a server operator from logging or perhaps even not logging, but generating immediate inferences and then sort of monetizing data flowing through their servers. And there are powerful economic incentives to pursue that kind of monetization. So what does that mean? I think companies, civil society, governments need to fairly quickly negotiate how to layer some technical purpose limitations on top of the MCP architecture and be mapping along the way how those interact with existing law. And I think that's harder than it sounds, even as it is an urgent problem, because I think detecting when agents are sort of violate purpose limitation or use restrictions is genuinely difficult. I'm not sure, and this is where lawyers and policy people, Matt and I, are sort of trying to interact with the technical community more. Do we have the tools to map what's data is flowing through MCP servers, compare that against contractual terms and terms of service in the legal landscape? So I think the bottom line is technical architecture and legal policy frameworks need to be developed together and in pretty quick feedback loops, not in sort of a slow sequential way.
So let me make a provocative argument or question wearing my industry hat. Where essentially, is there a role for government here, or is self-regulation of the pipes working? And maybe just like to steelman the self-regulation is working argument, MCP is an open interoperable standard that came from industry, not government, and not through even traditional standards bodies. I think companies in some way are incentivized to give users control over their data flows, and especially to get into these sort of like very valuable customers in regulated industries, right? Health, finance, all these places require giving users a lot of fine-grained control over their data flow. And similarly, just like on the security side, companies are racing as fast as they can to lock down the major attack vectors like prompt injection. Is this enough? Like, why is this enough to just like lead to the safer ecosystem for agents that we want? And if not, what do you see as the role of government there?
Yeah, I mean, as you mentioned, there have been a lot of positive developments with MCP on its own. But that said, I still think there is a role for government. But that said, government should not be overly prescriptive about the technical pipes themselves, and instead should probably focus on creating fair outcomes-based frameworks around agents and MCP, which is something that I think got mentioned earlier on this panel. So right now, it's still early in the development of agents. Things are moving incredibly fast, and I think we still need to kind of see how things will ultimately be adopted. So it's about striking that balance between having governments not regulate paper specifically in these early stages, while also having and preparing for democratically accountable bodies across the be ready to address the privacy challenges that we wrote about in the paper. And an example here would be with the early internet. The US didn't overregulate fundamental technical architecture like TCP/IP, and I think that's probably a good example that we should follow with MCP. But what the government can do with this outcomes-based approach is guard against specific harms like privacy harms, problematic market concentration, cascading security vulnerabilities, and then by that same measure, kind of promoting positive outcomes, especially with MCP, like portability, interoperability, and purpose limitation.
Very quickly layering on, I know we're pretty much at time. Building on what Matt said, governments should take a broad enough view of the good outcomes that society should be pursuing. And so one of the worries I have, it's not specific to the MCP context, but is that we're drifting toward a narrow focus on AI adoption as an end. But that's not an end in itself, right? The public interest goal should be that AI tools genuinely improve lives by minimizing risk to safety and privacy. And so that means that security vulnerabilities in the agentic ecosystem are vital to address. And I'm really heartened by NIST focus there recently as well, but that's not sufficient on its own. The ads discussion we had, very quickly earlier illustrates the broader stakes. That's the type of place where democratically accountable lawmakers and civil society have to engage as well, not just industry.
Thanks to all of you. That was great. We're going to move on to our final paper and author of the afternoon. So I'm going to introduce Christina Lee, who's going to be presenting her paper, Beyond Algorithmic Disgorgement, Remedying Algorithmic Harms. And she's going to be joined by Jevan Hutson from Grindr. So I'll turn it over to you both.
Thanks, Justine. It's a real pleasure to introduce Professor Christina Lee and her terrific paper, Beyond Algorithmic Disgorgement, Remedying Algorithmic Harms, forthcoming in the UC Irvine Law Review. Professor Lee is a visiting associate professor of law and a privacy and technology law fellow at George Washington University Law School. Professor Lee's work sits at the intersection of privacy, consumer protection, and emerging technologies. And this paper exemplifies, I think, what she does so well. Taking a fast-moving enforcement trend and slowing it down just enough for us to ask whether we're getting the theory and the remedy right. The backdrop for this article should be familiar for everyone on this Zoom. Around the world, AI regulation has largely taken an ex-ante form, such as risk assessments, impact assessments, or mitigation duties. But as Professor Lee reminds us, harms inevitably occur, even in well-regulated systems. That means we need to think seriously about ex-post remedies. And as she notes, remedies are not just cleanup tools. They shape incentives and define the real contours of compliance. Her focal point is a remedy that has captured enormous attention over the last several years, algorithmic disgorgement, which is the destruction of models derived from unlawfully obtained or unlawfully used data. First used by the FTC in 2019, it has since spread across enforcement actions at the FTC and even into private litigation. But Professor Lee argues that what we call algorithmic disgorgement has actually evolved into two distinct remedies. First, data-based algorithmic disgorgement, which focuses on harms in a model's creation, especially unlawful data collection. And second, use-based algorithmic disgorgement, focused on harms caused by a model's deployment or impact in the world. Although they share the same mechanics, model deletion, they are grounded in different legal principles. The first tracks traditional disgorgement logic. A party should not profit from its own wrong, whereas the second resembles consumer protection logic, more akin to a product recall. And here's where the paper becomes, I think, especially powerful for policymakers and enforcers. Professor Lee shows that when these remedies operate in the real-world algorithmic supply chain with multiple actors, shared models, layered training and development, they can often misfire. They might fail to meaningfully burden the actual wrongdoer. They might impose disproportionate consequences or sweep in innocent third parties connected through shared infrastructure. Her conclusion is not that we should abandon strong remedies. Rather, she distills two key considerations for any algorithmic remedy. First, is the remedy responsive to the nature of the wrong? And second, what is the full impact of the remedy across the AI supply chain? As well, she also calls for a diversity of remedial options, not simply a one-size-fits-all instinct to delete the model. For lawmakers, regulators, and practitioners in this Zoom, the stakes are markedly clear. Right? As AI governance becomes increasingly post-market, remedies may become the most consequential regulatory lever that we have. So with that framing, I'd love to turn to some questions. First off, Christina, you argue that remedies are under-theorized in AI governance. Why do you think so much of the policy conversation has focused on ex ante regulation? And what do we miss when we neglect remedies? And potentially for regulators in this room, how should remedies oriented thinking shape how we draft rules in the first place?
Yeah, thank you so much, Jevan. I am so delighted and honored for this opportunity, especially with such a wonderful interlocutor whose earlier work on model deletion really informed this work. And the question about the under-theorized nature of remedies is such an interesting and important question. And I think a big part of it is because AI harms are just really hard to reason about as concrete individualized harms, right? They're everywhere. AI is everywhere. AI harms are everywhere. They're really diffuse and they're really hard to detect on an individual level, right? So when I don't see a job posting for a lucrative position on LinkedIn that someone who's equally qualified but of a different demographic might see, how would I even know that I didn't see this ad? So it's really hard for individuals to even know that they're being harmed. And even as these harms in the aggregate can be really, really significant. And so it's probably easier to grapple with these things in terms of ex ante regulation to contain the aggregate level of harm. And to be sure, I think ex ante regulations are super, super important. To the extent possible, the best case scenario is no harms occurring at all, right? Like the best case scenario is for us to not need remedies because no harms occurred. But that's just not possible. Harms will inevitably happen even with the best ex ante regulation, either because those harms just weren't properly accounted for during the ex ante deliberations, or because those regulations were violated. And so that's really where remedies kick in. Harm has happened. What do we do now? And that's what we lose if we neglect remedies, making sure that harms that occur, that will inevitably occur, can adequately be dealt with, plugging the holes that might exist in the ex ante regulation. I'm giving you and me some assurance that our rights that these regulations are meant to protect will actually mean something, and giving regulations actual teeth. So I think with as we think about ex ante regulation, those are really important. But I think we just need to be cognizant of the fact that they won't do everything we want them to do. So there needs to be some backstop, and I think the backstop is remedies.
Double clicking, I think, on that backstop, again, you distinguish between data-based and use-based algorithmic disgorgement. Could you sort of briefly explain why it's so important for us not to collapse those into a single category? And do you see enforcers being sufficiently attentive to that distinction as it's been deployed thus far?
Yeah, so in my paper, I look at how enforcers, primarily the FTC, though certainly not the only entity that's been using algorithmic disgorgement, has used this relatively new remedy. And I divide them into two categories based on why they're being used, right? So like the distinction is really based on the underlying offense. With database algorithmic disgorgement, as you mentioned earlier, it's really all about how the model came to be. As Alicia mentioned earlier, modern AI runs on data. So if the training data that led to the creation of this model is tainted, illegally collected, for instance, then the whole thing has to go. That's the very first instance in which the FTC has used algorithmic disgorgement in 2019 against Cambridge Analytica. And so there, Cambridge Analytica was alleged to have collected data and personal information deceptively. So the whole data, the model that was built on the data had to go. Use-based algorithmic disgorgement is a more recent innovation. And the kind of harm that this kind of algorithmic disgorgement goes after is really all about what happens after this model's been created. It doesn't really matter if the model came to be in a legal manner or not. It's really like product safety recall, where we don't really care why this thing has defects, but it does, so it's got to go. And the distinction is really important, in my opinion, because it really goes to why we're invoking remedies, which then flows to how we should be using a specific remedy and when they actually make sense and when they don't. Remedies, as I talk about in my paper, should really match the offense and target the parties that are responsible for the offense, because that's how you shape behaviors, right? Like that's how you make sure that the future people who are similarly situated don't make the same mistakes, don't make the same violations of law. And so diving really into the remedy a little more to categorize them in terms of why they're being invoked can really help us make sure that we're using the right remedy at the right time. And I do think regulators are starting to grapple with this, and we'll just have to see where that goes from here.
Lots to watch out for. Before we dive into audience questions, encourage folks to put questions in the Q&A box. I want to zero in on the sort of algorithmic supply chain problem. You emphasize sort of the many hands and the supply chain reality of AI systems. To you, what is the most sort of common mistake enforcers make when they fail to account for this sort of supply chain complexity? And how should regulators think differently when foundation models or shared infrastructure are ultimately involved?
Yeah, I think it also comes down to how remedies should be something that shapes behavior, right? Because so to deter people from acting similarly in the future and like also compensating people who have been harmed. And I think one thing that happens when the supply chain complexity isn't properly accounted for is the remedies end up hitting the wrong actor, right? And so it just ends up being ineffective in shaping behaviors because that actor wasn't the one who could have rectified the harm done or similarly situated to other actors who might do the same thing in future cases. When an AI harm occurs, I think it's really important to remember that it's not just the deployer of the system, the person who immediately used the AI system that ended up causing the harm involved. It's all these different actors who come together to create this one AI system and use it. And even if the end user is the most obvious party involved with the harm, they might not actually be the party that could have done something differently. And so if we don't take into account the complexity here, then we end up just not having an effective remedy, and the remedy just loses its teeth. And going back to my earlier point about how remedy is so important because just me it gives regulations actual teeth. It's just getting the wrong teeth, right? And so I think to your point, it becomes really tricky when we start thinking about this issue because we have shared infrastructures that's used and adapted by someone else for all sorts of different ways. And so how much onus do you put on the foundation model developers versus other people who've tweaked this model versus the people who deployed this model? It is going to be a fact dependent question and it is going to be very context dependent. So I just don't have an easy answer, unfortunately. But I think at minimum, what regulators should really think about when they're dealing with like an issue of algorithmic harm is they should really look at the full picture of all the players involved leading up to an algorithmic harm and trace the harm carefully through all the different players as opposed to just focusing on one specific target.
So I guess moving on to questions of enforcement, obviously we've seen quite a bit of transition at the Federal Trade Commission, and I'd venture a guess that we might not see this remedy be deployed, at least under the Ferguson administration. I guess sort of a two-part question on enforcement. One, in your view, do you expect to see, state attorneys general or European data protection authorities potentially take up this remedy in the absence of enforcement at the Federal Trade Commission? And then, to those audiences, be they again state attorneys general enforcing state privacy laws or state consumer protection laws, or to European data protection authorities, any practical guidance you'd give to them if they were, looking to take up the torch of model disgorgement?
Yeah, I think you're right, for better or for worse, that the Ferguson FTC is unlikely to be picking up this tool anytime soon. But I do think European authorities and state attorneys general might be seeking this remedy, right? The EU AI Act, as I go into some depth in my paper, does talk about product recall and withdrawal of AI systems, and I think there is good argument to be made that is really analogous use-based algorithmic disgorgement. And the European Data Protection um, Board recently said that in cases where data is collected improperly, then model destruction might be the right remedy, right? So I don't think this remedy is actually going anywhere, even though the progenitor of this remedy, the FTC, might not be using this as much. And I think with state attorneys general as well, I mentioned in my paper, Texas actually asked for algorithmic disgorgement some years ago as well. Not necessarily always aligned with what federal government has been doing, but I think a lot of state agencies across the board are very interested in making sure the harms of AI don't come to pass on their consumers. So I do think state agencies might be going in that direction as well. And what I would want to say is that um, with great power comes great responsibility, right? This is this is a potent remedy. And I do think there are places where this remedy makes a lot of sense, but I think just we have to be mindful of all the unintended consequences of this remedy. And so I would just say, take a pause and make sure that you really want the full ramification of this remedy before actually deploying it.
So I guess one last selfish question I have is someone also interested in remedies when it comes to data-intensive systems. You point to alternative remedies like fine-tuning, machine learning, and other sort of tailored interventions with the time that we have. Are there any other remedies that you're particularly excited about or see as sort of most promising in the near term?
Yeah, I am really interested in where the research on training data attribution goes, right? So I think with when it comes to database algorithmic disgorgement, I think a more tailored remedy might be to see, especially in data systems that have just like vast amounts of data, of training data involved, and like if a small portion of it was tainted, then I think something like training data attribution can really go a long way in starting to design a more tailored remedy there. So I'm really excited to see where that goes.
So thank you, Christina, and thank you so much for this work and for joining us today.
Thank you.
Thank you both. And thanks to everyone who was on the call today for joining us and for our speakers. I'm going to briefly pass it along to our VP here for US policy at FPF, Matthew Reisman, for just a couple brief closing remarks.
Thank you, Justine, for your moderation today and your leadership of the effort to bring the 16th Annual Privacy Papers for Policymakers to fruition, as well as the entire terrific FPF team that worked with you to make it possible. Thank you to our speakers and discussants. What an extraordinary set of discussions we've just had. From core concepts in privacy, AI, and technology law and regulation to the very frontiers of technology, you've taken us on a journey towards deepening our collective understanding of pressing challenges and pointing us towards potential solutions. Thank you for taking time to join and share your invaluable insights, and to everyone who made time to attend, listen, and ask questions today. If you haven't done so already, please take a moment now to register for our Part 2 webinar scheduled for next Wednesday, March 11th at noon. You can find a link to sign up in the chat. The session will feature discussions with the authors of a set of fascinating papers on the themes of privacy governance and regulation. You won't want to miss it. Thank you again, and we look forward to seeing you next week.